The woman who ran South Africa's anti-corruption directorate refuses to answer. Advocate Andrea Johnson. Until recently, the head of IDAC, the unit that arrested generals, and on the 29th of July 2026, in front of the Madlanga Commission, she says this: "I elect not to answer questions so as not to incriminate myself." Her own affidavit told the commission the allegations against her implicate me in alleged criminal conduct. A docket now sits with the NPA, waiting on a decision about whether she is prosecuted. She has not been charged, she has not been convicted. But the chairperson tells her the evidence that she shared a police docket with her friend, General Khan, is so strong that if not counted, it may easily lead us to the conclusion that you did share the docket. She admitted the friendship herself. "I considered him a very good friend." And that's just the ending. Before it, a 360 million rand tender, 50 million rand of public money gone. Charges against the national commissioner she conceded were wrong. Arrests she accepted were a misuse of power. Hit like, subscribe, turn the bell on, let's go inside.
Additional to. So General Masemola then has to be charged under the PFMA all by himself. So what would the PFMA charges be additional to? What would the PFMA charges be additional to? Nothing. You get my point? Yes. So it's on that basis that I say your attempt to just force the PFMA charges being additional simply does not work. Do you agree? It doesn't. It doesn't. Because all that General Masemola is charged with are the PFMA offenses. So when you look at him, those offenses, insofar as General Masemola is concerned, are not additional to anything, are not related to anything. It's just those PFMA offenses only. And you cannot force the additional by merely relating to charges faced by other people, charges that have nothing to do with him whatsoever. And the cruel example I give actually makes the point abundantly clear. Do you agree?
I agree, it makes the point clear.
By the legislature or the legislator. It's a conscious choice of word. Otherwise, they would just have said relating to these statutory, or rather, offenses arising from these statutes, and then the statutes would be itemized. The use of additional is because there must first be other offenses. Otherwise, additional simply does not make sense. You must accept that.
I leave it there, Chair.
Do you agree that otherwise
I have to agree with your reasoning.
Sorry.
I have to agree with your reasoning.
Thank you.
I made the point I thought I need to make.
Yes,
it is based on my understanding. And I have...
Yeah, I suggest to you, or as other people would say, I put it to you that your reasoning in this regard...
will not hold water.
It simply does not. Thank you.
Advocacy law
of corruption or a successful prosecution that comes under PRECA. That was never the real intention. In my view, the intention was, as I say, get him arrested with the spectacle that comes with it, get him charged with a consequence that naturally will follow, which is the minister, and hopefully even he, National Commissioner, would say it's untenable for me to remain in this position while I'm undergoing a criminal trial, and that was its only purpose. That's what it looks like to me. You may comment if you want.
And I do understand your reasoning, Commissioner Baloy, but at no stage was there an intention to make a spectacle of anything. The prosecutors looked at the case in its totality. And as I explained this morning, it relates to, I accept, the only part that I do accept is they didn't draw the link between the two. That in itself does not make the conduct malicious, and there was no intent to put him on show. It was to charge him as they did. That link is not there. That cannot be taken away. But it should therefore not be seen as it was used as an instrument. They still firmly believe in those PFMA charges as they put them. And in my discussions yesterday, I did highlight that the Commission does find we have, where is the link between the two? Hence my explanation this morning. I took your point, but I have to clarify, there was never an ill intent. It might have been clumsily put in the way it is.
Or incompetently
put, but that does not make for ill intent at all.
Corruption when he is not. When he is charged with the statutory offenses provided for in the PFMA, why was he lumped with these people? At face value, it seems to me that this must have been done to embarrass him, to taint him, and to make the public, or to cause the public to see him as also being complicit in fraud and corruption. People are not going to, ordinary members of the public are not going to analyze this. He stands there, people charged with corruption, fraud. He stands there with them. And most of the noise when the case is talked about is going to be about the fraud and corruption. People are not going to delineate and say, but not Masemola. Do you see what I mean? So this was done, I suggest to you, to embarrass him, to taint him, and to make him look as if he too has committed fraud and corruption. That was calculated, I suggest to you. What do you say?
Chair, I understand. I gave the contention that I did, that the prosecutors put him in one matter because there's the serious complex fraud corruption, and it would be one matter when they lead the evidence with the PFMA. I'm giving you the explanation that I have for the prosecution. I accept that this matter, he should be separated, but at no stage, Chair, was there an intention to embarrass. I can understand the optics thereof, but at no stage in the charging of Commissioner Masemola was there an intention that he be embarrassed.
Was that correct? Insofar as he is concerned. Remember, you just said, in response to my last question, you just said evidence of the commission of corruption and the commission of fraud is not admissible as against General Masemola. And if you look at 156, that is what a prosecutor must tell the court as to why the prosecutor is joining the accused persons together. So if you accept, as you did in response to my last question, that evidence of fraud and corruption is not admissible as against General Masemola, you do not get off the starting blocks under 156. Do you agree?
I agree.
So
I was giving you the discussions that we had.
Which were wrong ultimately in terms of the decision that was reached. Do you accept?
I'll accept it.
Thank you.
Thank you, Chair.
And whole affidavit, we don't know when she told him, right? So if we don't know when she told him, we are not in a position, and that you must accept, we are not in a position to say he delayed actioning her advice because she doesn't tell us when she informed him. We are not in a position to say because of his delay after she advised him, SAPS incurred 50 million rand expenditure, which it would not have incurred. It's not there aren't facts in this affidavit that make us able to conclude that therefore he delayed and he's liable, he failed to secure the monies or the assets of SAPS. You accept that?
I accept.
You recall we started this conversation having considered what you stated, what you discussed with members of ad hoc, and There I reference page 586 where Mr. Ngola told you that there was an allegation that IDAC is actively participating in a well-coordinated attack against General Mkhwanazi, General Masemola, and General Khumalo. Are you aware of it? You said you've heard of that allegation, but there's no truth to it. After this entire exercise we've gone through, do you still maintain that there is no truth or there is no basis to even believe such a narrative or an allegation?
Chair, I maintain that there was no, sorry, I don't have my file for the,
No,
if you just repeat the words.
The engagement at ad hoc?
Yes. Can we just stand back and let them continue with their work? It was
Advocate Johnson, I want to say if that's the explanation he gave you, it's a false explanation. Those individual members and anyone else in the world was under no bail condition that they could not, that's one reason, that they could not deal with any witnesses. There was nothing like that. If indeed the issue was to determine whether General Khumalo breached a bail condition, it was simply, and I'm sure Advocate Manilal knows that, you know that, it was simply a matter of asking General Khumalo, did you authorize an arrest of Mr. Adams? It's as simple as that. So if he gave you that explanation, it's false. He's not telling you the truth about why those questions, because that doesn't answer who went there, what are the names, give us the flight details. It doesn't answer the question whether there was a breach by General Khumalo of his bail condition. So no, I'm sorry, if you believe him, then something is wrong in this scheme of things. You should have, as soon as he said it, you should have seen it on his face, but that cannot be, it doesn't make sense. That you would go that way to try and determine that General Khumalo, whether or not General Khumalo has breached his bail condition. It's a false explanation.
So, Commissioner Baloy, I hear you. I'm conveying the reason that was given. But Commissioners would, and Chair, you would remember my answer yesterday. I did say that if, in the manner that this process was used and what was requested by asking about PKTT, then it is an abuse of the process. That would have set that matter aside. That was not done. And now the question is why? Why wasn't I informed of the different statements? And what is the purpose then, Chairs and Commissioners, and forgive me if I'm rambling, but I have to think it out loud because it does not make sense. And I'm saying that there must then have been something else going on that I was not aware of. I cannot tell you what the something else was. I wish I could. I'm not therefore disagreeing with your counsel. I just needed to put it in a way that I'm unable to take it further than that.
What could the something, as you put it, possibly have been? Surely you must have your ideas. Because one could easily say it was improper motives. But I'm not necessarily suggesting that. I want your own thoughts. What could the something possibly have been?
The something, Commissioner, I take it also from my time at the DSO, the Scorpions as they were. A lot of the times, and history had shown that, you find that staff get overzealous in wanting to present their case. But more often than not, you find that they engage with persons outside the purview of the work we're supposed to do, and you are not privy to that engagement. Mm-hmm. And so the mind you expect them to bring to bear on the mandate and on the cases is what you're engaging them on. It has been a past experience. In the way things happened this past week, it seems that there are other actors that might have been engaged with for us to be where we are.
And when you talk about other actors, are you talking about undue influence, perhaps?
I don't want to put it so harshly without having any, but to say that persons might have, for motives known to them,
that had nothing except for factual conclusions. You acted. It had to be your decision, you as the head of IDAC. It had to be your decision, and indeed it was, for any investigation to have gone on in the first place. Cut a long story short, I do not understand why you would want to blame others.
if I may.
As it should have, the buck stopped with you. And indeed, from where I'm sitting, it did.
And that is why, as I was carrying on with the Adams matter, that brought starkly home, from start to finish, the
Yes.
responsibility across the board.
Yeah.
In the first two instances, there are different instances that I used, as I hadn't been aware of them. But I sit here today knowing that I have to take responsibility
Yes.
for all the actions that flowed, intentionally or unintentionally. And I will be judged for those actions.
Yes, but why I'm going back to where we started on the first day of your testimony is because in the context of blaming others, you are referring to the Section 27 affidavit. And it is in that context that I say you cannot blame others.
It is my responsibility.
It is and it was your responsibility.
I accept that, Chair.
Thank you.
Yes.
Okay, thank you.
I was going to say it's the same with the charge that in her CV she misrepresented facts, but the charge sheet does not say what fact is misrepresented and what is the correct fact. And Commissioner Baloy's point that the DPP in file 62438, all he or she then says is that having considered your memo and the charge sheet, they are satisfied that a prima facie case has been made out against the accused, and they concur with your decision to charge them. So it means they only considered the two documents that Advocate Sello and Commissioner Baloy are referring you to. And it's the following day. I mean, there wasn't even a week to consider and come back to you and say, where is this, where is that? What is Mkhwanazi, what is e-vetting? They seem to have rubber-stamped what was in the charge sheet, and there wasn't any engagement or consideration, because I doubt that any such engagement would have taken a day to finalize.
I accept that, Chair.
Thank you, Commissioners.
For any person, so you cannot sit there and seriously say, well, you know, because of how we did it, that mitigates anything. It doesn't. If you accept that as a matter of law and fact, there was no compelling reason to arrest these people, to bring them to court. If you accept that, then you must accept that it was a misuse of the power and discretion to arrest, because its sole purpose is to bring a person to court. And if you have other ways of bringing them to court, that must be the default. And that is a default that is not only about respecting human rights, but you know, we live in a society where you cannot infringe, you cannot breach the law, infringe human rights, take the most intrusive action and then say, well, at that time we were subject to criticism in other cases that we are selective. Then that's an admission that you use that process of bringing a person to court for a purpose other than what the law permits and prescribed it should be used for. So you in fact concede in your long explanation that that power was used for a purpose that had nothing to do with ensuring that these people do come to court. What do you say to that?
I hear Commissioner Baloy's explanation, and I'm saying that is the route we followed.
Did they appear? Did they appear in
your
court?
Argument
Okay.
that it was not. There are less intrusive means.
Yes,
that
and that
should
and
have
that,
been used.
Yes, and
I'm
that it
not-
was an abuse of that process that's
I'm not-
available to you.
I'm not taking it further than that.
You accept that?
I accept it.
Did they appear in court on the same day? Do you remember offhand?
I can't remember offhand. I'll have to check.
All right, but most importantly, it is you accept that in these circumstances, an arrest was not necessary. They could have been summoned to appear in court whenever you've eventually presented them to court, and there would have been no harm to the state's case.
I accept it.
You accept that? Thank you.
Arrival was not to inform him. I have a sneaky suspicion that he's got a telephone, he's got a cell phone, that somebody within IDAC, the number may have, including yourself, considering his seniority. And that was easy to call him, to send him a message, a WhatsApp, Signal, what is the other new one? The Swiss one, we learned something.
Okay, I don't know about the Swiss one, but
I learned.
I take your point.
Yes.
I'm taking your, I
So
take your point.
I'm saying, actually what you are stating, it's a rather misleading. They went at the airport to arrest him, period. They went there to arrest him. And by arresting, it doesn't mean they have to speak gruffly to him. They could be very well nice. But at that point, he no longer had an option to go anywhere but straight to Brooklyn Police Station. That in any language constitutes an arrest. Would you accept that?
I'm accepting your point.
In fact, it's the 29th of April. 29th of April, 2025. And we know from General Matlo's Section 27 referral that by the 15th of May, General Masemola had terminated that contract.
So 2 weeks later, 2 weeks after this report, General Masemola had terminated the contract.
I get it, Chair.
And remember, as Advocate Sillo said, 5.1.2 said he must seek legal counsel on how to proceed. So one must assume that in those 2 weeks, he sought legal counsel.
That is correct.
Thank you, Commissioner. So, and I know I read it very carefully. Where I land is, insofar as General Masemola is concerned, it doesn't cure the shortcomings in the Section 27 affidavit as submitted by General Matlo, because it is absolutely silent on either irregular conduct, unlawful conduct, criminality attributable to General Masemola. Is that your, and I know perhaps you only had an hour as well to go through it, is that your interpretation as well?
From the
From the
preliminary,
document
yes.
itself, yes. Then I think that then settles the matter. And it goes back to the concession you refused to give me, and you say it's dependent on the contents of this document. You've seen the document now. Are you going to agree with me? You said it would be irresponsible, I think, to agree with me without having had sight of the preliminary, the interim audit report you have now had sight of. So, on the basis that the condition has been met, I take it won't be irresponsible to agree with my conclusions.
Let me think. We didn't finish before lunch, so maybe I'm still disagreeable. No, I agree.
Thank you.
I agree.
Actually, there was this condition.
No. I see for the first time in this hearing this condition as it is. That was the summation that they gave me for me
It was
to
not
sign.
the actual order.
It wasn't the actual order.
So they drafted a letter for you, explained it, I take it, and you took them at face value, and you trusted them implicitly and signed. That's about what happened.
Because it had to go to the National Commissioner, yes, what had transpired in court.
And once again, you didn't satisfy yourself that those were the correct conditions, actually.
No, I didn't ask to look at the conditions.
Okay. Commissioners and...
I think it's more, especially in the light of what you said now as you're sitting there, that this bail condition is too wide. These people are employed in head office. You may not have seen the order itself, but you sign a letter that says they may not go anywhere in the whole country. That is crime
Sorry.
intelligence.
Yeah. I didn't read it that way, in the whole country. For me, it was any
Crime intelligence
crime
office.
intelligence office, and for me, they are bound here in Pretoria. I didn't see that as in the whole country. That is why I'm saying, Chair.
And we can accept that it's established that the condition was not asked for. Thank you. Thank you, Ms.
Thank you. And if I could just perhaps add to that, you don't have to take our word for it that it was not asked for. The judge in the High Court, that's precisely the basis of his overturning it, because it wasn't asked for and the judgment states as much.
Yeah, it's just I am taken aback that there's a condition that was not asked for. It is not something that I have experienced or
Indeed.
engaged with other colleagues about. So,
And then it's not something that you wouldn't expect to happen in any event.
not on the local criminal record center document it is only found there if an investigator circulates his warrant, and that is when it is seen. I have no explanation for why the warrant was not circulated, nor do I have any explanation for why, despite there being an instruction that he cancel the warrant, finalize the investigation, take it back for decision, warrant is not cancelled, docket is closed, and docket is filed. This is a police warrant, and the police will do with this warrant what they do with warrants that are not cancelled.
Okay.
It's not my decision to make. It most certainly isn't.
I think your decision was confronted with what you are confronting. One of your investigators has got an active warrant. He, in the course of his duties, is arresting other people. That is a problem for you as the head of IDAC. The warrant is for the police to deal with, to execute. But the question was, what do you do with that? Can he morally be permitted to be arresting other suspects out there when he himself is under an active warrant of arrest? I think.
No.
Yeah.
This matter, the police must act as they want to act.
And what does IDAC do in the
IDAC
interim?
this has to go to the judge, the IDAC judge, because this becomes one of those issues.
Than just being invited to a 50th birthday celebration by a colleague. You have a personal and deeper relationship with General Khan. Would you agree with that?
Yes, ma'am, I considered him a very good friend.
A very good friend. And in fact, on reading of this, it sounds like you visited each other's families.
No, we didn't.
You have been, I don't want to flight them.
Yes.
Personally, I don't.
Yeah, but I can indicate that there might have been an occasion where he would have invited us,
Yes.
but we have not, I have not gone to his home. He has not come to my home.
Advocate Johnson. And if Advocate Johnson were to confirm to you that theirs is a very close relationship to a point that they greet each other by stating, saying words like, "Hi, gorgeous," then it makes my point without necessarily having to use the chats. So the chats are not going to give me any relevant evidence for anything except to establish this very close relationship, contrary to what she had stated originally in her statement. Thank you.
So, Advocate Johnson, if you just look at chat 5, 6, 7 on 3249, and then it continues to 32. That is a sign of people who have a close personal relationship. And you can see there that it's not an IDAC investigation. It's really two people who are friends, and this relates to a favor to him. It has nothing to do with IDAC's work. If you just look at 3249, I will just read, for example, where he wants to know who's plotting against him, and you are to assist him. And he suspects that it is the Hawks that are plotting against him, and the two of you decide to meet, and you arrange for him not to sign in the normal course, but to come in via the VIP entrance and come directly to your office without going via reception. I mean, that's a summary of it. I don't want to go into...
Yes, it wasn't the Hawks. I want to make that clear. But it
The point is, this is not a VIP visiting IDAC offices.
No, this was my friend.
This is a personal visit by a friend, and when you say to him, come via VIP entrance and don't sign in, you're not doing that for a VIP coming in his official capacity. You're doing it for your friend who's coming there to discuss personal issues.
I accept that, Chair.
And that is the whole point, to demonstrate that you have a very close relationship and the lengths you'll go to accommodate one another.
Where I read on day one, and if Chair would allow me to just reiterate, I said the notice requires me to deal with allegations against me testified to by Colonel Kobus Rule Officer, Captain McLean, and Witness O. The allegations as summarized implicate me in alleged criminal conduct. The allegations are contained in a docket, which is now with the NPA for a decision on whether I should or not be prosecuted and further handling. That this is so, Chair, was confirmed by the NPA on the 10th of July 2026, as well as by the witness McLean when he testified on that day. Now that the matter is before the NPA on the basis set out above, Chair, for a decision on whether I should or not be prosecuted, various consequences emerge. One of those consequences of the need for me to have my rights protected. Thus, when I testify on those matters, should I be called upon to do so, Chair, I will humbly exercise my right not to incriminate myself under Section 35(3)(j) of the Constitution of the Republic of South Africa, read with Section 3(4) of the Commissions Act of 1947. These instruments guarantee my right against self-incrimination. If I could just read the last paragraph then, Chair. I hold the view that the Commission's fact-finding mandate does not override my constitutional protection against self-incrimination under any circumstances.
General Khan, very strong evidence. What could have countered that would have been testimony from you, which, as we now see, you are not willing to do. Without contradiction, that very strong evidence may lead to a conclusion by us that those witnesses were telling the truth.
I understand.
I hope you understand that this has nothing to do with the unacceptable drawing of inferences from your failure to testify. That's not what I'm talking about. What I'm saying is the evidence on its own is so strong that if not countered, it may easily lead us to the conclusion that you did share the docket with General Khan.
I understand.
Yeah. So, which perhaps may obviate
Absolutely.
the need for us to go through this laborious and painful exercise.
Indeed, Chair. It's too horrific to contemplate. I too wouldn't want to go through it. But then it goes further as regards inferences that we suggest be drawn by the Commission as all the evidence tendered by witness O must therefore be accepted, particularly in circumstances where you were provided with an opportunity in this Commission to contradict any aspect of her testimony. If you don't, then the Commission will have no basis to reject any suggestions and any conclusions she could potentially have drawn from the evidence that she has tendered. Are you happy with this? Is your response to the opportunity to challenge any of the evidence of the three witnesses I've named?
Thank you, Chair. And I must at the outset indicate that this is not a decision I make lightly, nor do I make this decision to frustrate the Commission. I have come to the Commission, as I have over several days, and have answered as best I could on all matters. This matter, however, affects me directly. I am aware then that should I choose not to answer any of the questions, they remain unchallenged. I elect not to answer questions so as not to incriminate myself.
Sorry, and that will be in relation to all aspects of each individual witness's testimony.
That is correct, Chair.
Yes.
Can I just check, does that include?
Thank you, Chair. Chair and Commissioners, I guess that takes care of that issue and matters arising from the testimonies of Mr. Matlin, Mr. Rule Officer, and Witness O. And based on the position that Advocate Johnson has assumed, notwithstanding a formal invitation to her before the Commission to persuade the Commissioners otherwise as to the correctness of that evidence, then there is no point in going through the evidence because I think she's given a total answer to those. And I guess the cards shall lie where they fall. I don't need to take that topic further.
That means you should we take it, you will then make submissions to us that the evidence of those witnesses should be accepted as true.
I make the submission now and point out to the Commissioners that that evidence stands wholly uncontroverted. The singular witness who could have challenged that evidence has elected not to. The reasons thereof become irrelevant. What is relevant is the weight of that evidence before the Commissioners. And I argue that it has to be accepted because there is no other basis, in fact or in law, to question the accuracy and correctness of that evidence. Now, my interest in this particular message is General Khan is sharing with you details about a bust he was involved in at a business premises in Eraton. Gives the date of the 9th of July. Second paragraph, we've had testimony regarding that bust. It involved on record the seizure of 541 kilograms of cocaine. You might have heard about it, or perhaps not, but what I state to you is factually correct. I'm interested in what General Khan says to you at midway the second paragraph, and he states that 552 blocks of pure cocaine were seized with a street value of approximately 200 million. Why it strikes me is we've always known the Araton bust to involve 541 kilograms, and that General Khan was a part of that eventual seizure. I find it interesting that in a message to you, he's got a slightly different weight of 552 blocks. So just to confirm that you got this message, not suggesting that you know anything about that.
And just to confirm that the reason this message would have come is at the time in 2021, we were dealing with organized crime matters. And very often, even General Kadwa, for example, would activate us to say, at the DPP office, there is such a matter, so that we looked out for the matter and we were able to allocate resources to them. But this is the message I received.
Yes.
And so your conundrum is real about why in this message you have 552, which must be the correct number.
Which must be the correct number, because one would think this message was created contemporaneously with the seizure.
And probably on the scene at the time.
Exactly. And 5 years later, we sit here and we are talking about a different tonnage.